The Trade Minister, Simon Birmingham, there announcing Australia is taking China to the World Trade Organisation over its decision to impose large tariffs on Australian barley earlier this year, sending a clear message there to China that Australia will do everything in its power to stand up for Aussie exporters being targeted by Beijing. Let's now bring in now the Liberal MP and former diplomat Dave Sharma for more reaction to that news. Dave Sharma, appreciate your time. Thank you. You've been quite vocal in calling for your own government to be more frank, be more honest in calling out China's behaviour. This week, Scott Morrison has done exactly that, a big move too there from Simon Birmingham. Are we now striking the right tone, or could we actually be risking further economic pain by aggravating China through pursuing this complaint with the WTO? We have more to lose here than China, don't we?
No, look, I think we're well within our rights and to do this, of course, and it's the appropriate course of action to take. The WTO is there to settle trade disputes between countries. China has signed up to the WTO. Australia has been a founding member of the WTO. We're all governed by these rules, and when we sign up, we agree to the principle that an independent body, an independent umpire, should settle disputes. They shouldn't be if countries can't resolve them themselves. Now, I think we've tried to resolve this dispute over barley with China directly through diplomatic and other channels. It's been unsuccessful, and I think we're taking the next logical step here to protect our barley growers, of course, but also to, more importantly, uphold the principles that govern the world trading system and the free trade system that's delivered so much prosperity in this past half century, including to China's own people.
You've previously made the point that China doesn't control all the leverage in this relationship. Considering, though, that World Trade Organisation action could take years, as the Minister just acknowledged, could a retaliatory levy on iron ore, as Matt Canavan has suggested, be the way to go? Is there something else we should be doing to demonstrate this to the Chinese?
Look, I think we need to be careful in engaging in a race to the bottom here, or throwing out the rules, if you like, the rule book, just because a country with whom we disagree has chosen to do this. The rules-based trading system has served Australia incredibly well. It's served served the world incredibly well. It's served China incredibly well. And if we were to go about and start unilaterally imposing export duties or tariffs or import duties on countries without any public policy justification, without any justification that's allowed under the WTO, then we would expect, and I think we could rightly expect, other countries to start doing the same thing towards us. And that's the beginning of the unravelling of the world trade system. I don't want to see that happen. I don't think Australia, which is a trading country, which is a country of 25 million but a top 20 global economy, who's always depended historically on the free movement of goods and capital and people for our prosperity, I don't think we're well served by trying to pick at threads of this system and seeking to unravel them. I think we need to be very careful about doing that, and that's why I think taking this dispute to the WTO is exactly the right course of action here. Doing unilateral steps I don't think would be wise.
Dave Sharma, as a former diplomat, I'm interested, were you shocked to learn in the Australian newspaper this week that Chinese Communist Party members are working in Australian consulates, or is that actually just standard? Is that a known risk that DFAT, ASIO are aware of and are actually used to managing?
Unfortunately, I wasn't shocked to learn it, and I'd say it's the working assumption of many of our diplomatic missions in overseas countries that they're the local staff that are working in those missions are, potentially also working for their host government, or they're subject to pressure and suasion from the host government, or they're being asked to and sometimes compelled to feed information back to their host government. Unfortunately, look, that's one of the ways of the world. Australia is not unique in that respect. There would be many other countries that have to operate under the same conditions. And I think what we've always done and continue to do is put in place compartmentalisation and safeguards and security screens and security barriers to make sure that only staff that have an appropriate security clearance, and sometimes those are only available to Australian citizens, and to make sure that only people who have appropriate security clearances get access to certain information, are available to sit in on certain meetings, have access to certain parts of the embassy, and that's what we'll need to continue to do. Obviously, this general threat, if you like, of espionage one country to another has certainly grown in the last sort of 10 years markedly, not only in Australia but also in our overseas operating environment. And so we always need to remain vigilant. But I think this is a sort of a case of more of the same here.
You were Australia's ambassador to Israel back in 2014. That's when Australia made that formal request to Israel for extradition of the accused child abuser Mark Khalifa. She's now lost an appeal against that extradition. Why did this process take so long, and are there any other appeal mechanisms here still left to be exhausted, or is this now a done deal?
I think this is now a done deal. I think the Supreme Court decision in Israel overnight was not only emphatic in its ruling, but emphatic in the judgment that accompanied that. And they recognised, the justices in that case, that what had been going on here for the past 6 years and now 74 court hearings really constituted an abusive process and an abuse of the judicial system by Ms Leifer and by her legal team. So I think we now expect the Attorney-General to sign off on this extradition order very quickly. I noticed in public comments overnight, Avi Nisenkorn, the Israeli Attorney-General, said he intended to sign off in a matter of days. And then Ms Leifer will be brought back to Australia. Now, I think this has taken much longer than it should have done. I don't think I have any doubt that the Israeli prosecuting authorities and Justice Department were relentless and always wanted to see this happen, but unfortunately Ms Leifer's lawyers were quite clever in finding ways to frustrate and delay and abuse the legal system. And it's important that people who are facing these charges obviously have access to justice, have access to due process, but I don't think now that Ms Leifer has exhausted all those avenues of appeal, I think it's very heartening that she will come back to Australia, where she will get a fair trial, where she will get the presumption of innocence, where she will have access to independent counsel, all those protections that we offer. But it's important that she faces her accusers. She is wanted on 74 separate charges of child sexual abuse from her time as a principal at a Melbourne Jewish school. And I think it's exceptionally important, not only for the victims, but for the stand we all take in abhorrence of these sorts of crimes, that she face justice.
Dave Sharma, I appreciate you joining us on Newsday. Thank you.
Thanks so much for having me.